Off we go. So welcome everyone to another session of the Web3 Tuesdays. So we meet every Tuesday at 2 p.m. set to discuss different matters of technology and legal and the Web3 in particular. And we have a great guest today, namely Derin Morgan. She's a litigation counsel at Meta. And we are going to hear from her about life as an in-house counsel in a tech giant like Meta. She's a great speaker, not only for her current employment, but also because she's very experienced. She spent some time at Volterra Fietta and the LCIA, among others. And also she's a co-chair of the Young Mute of Thursdays, which is a great initiative, quite similar to ours, but much better and much more established, which is for female practitioners that can meet every Thursday to discuss different matters relating to the arbitration profession. So without any further ado, I would leave the floor to Derin. And if you have any questions, please write them down in the chat and we can read them at the end, or you can also unmute yourself at the end and ask the questions yourself as you prefer. So Derin, the floor is yours. Thank you very much for being here.
Great, thank you, Felipe. So thank you all for having me, and I hope through this conversation I will be able to tell you a little bit more about being an in-house litigator, but particularly in the tech industry. And I think to kind of get to where I am today, I think it'd be helpful if I gave a little bit of how I got into the tech sector, because my journey was not particularly straightforward. So I've always been in dispute resolution. I started off as a purely commercial litigator, working with all sorts of industries, primarily with oil and gas and technology companies, so really not very well embedded in tech. And along that route, I decided that I wanted to expand the level of my dispute resolution background, and that included alternative means of dispute resolution, such as arbitration, but that also included mediation, that included learning more about different industries, not just the ones that I had primarily practiced in. And so I decided to go off and do this master's in the US. And while I was there, that is where I kind of had my first foray into tech. I took a tech course, which concentrated on technology and policy development. And I think one of the things that anyone who is very keen on the technology industry will be aware of, it's an area that's consistently developing in terms of regulation. It is consistently being scrutinized. And as a result, the tech regulation and policy always tends to be on the back foot. And that was one of the things we began to explore during this course. Fast forward, came back to the UK, did a few things before I got here. Felipe had kind of covered all of them. And then I ended up at Meta, where I'm doing litigation. Now, some of you might ask, litigation in-house, that doesn't seem that common, and that's probably correct. In-house litigation roles are really very few, far between. It doesn't tend to be an area where people would specialize when getting in-house. And that has been because historically a lot of work has been outsourced to other counsel. It hasn't been something that you've primarily had to do in-house. There's always been, particularly in tech, more of an unlimited budget, I suppose, due to the level of growth. And so I guess now, why are technology industries beginning to recruit in-house litigators? Well, I'm sure you're all aware that there is a proliferation of tech regulation at the moment. There's a lot of reasons why the technology industry has become scrutinized in terms of what we are doing. So that could be in relation to AI, data usage, privacy, amongst other things. And just the sheer number of different areas where technology kind of permeates business has meant that there has been more and more litigation that has come out of that. And this is why litigation is becoming a very big deal in-house. And I'm going to pause there for 1 second because I'm about to cough. So obviously, a lot of the work that we do in a big company like Meta means that our litigation is not standard. It's not the kind of thing where you can just go to a law firm and say, well, actually, you know, this is my issue, this is what I need. Can you please start this case and go ahead? And this is where someone like me would come in. In-house litigation in a tech company is usually very, very alternative. That's because at the end of the day, we're looking for practical advice. And unlike most lawyers that are working in litigation, there is an aversion to risk. Litigators are always trying to make sure that their clients are doing the least risky thing, making sure that you're doing what they consider to be the safest, most robust option for the courtroom. Whereas when you're working in the tech industry, you can't afford to do that. The speed at which things are moving, the speed at which AI is developing, privacy issues are coming up, regulation is developing, government scrutiny is coming up, just means that it's almost impossible at this point to think, well, actually, we're just going to have a standard approach to litigation. And so this requires companies to think, how best can we do this? And for us at Meta, that has just meant bringing those lawyers in-house, capping costs, making sure that you're getting people who understand the business appetite for risk, understand what kind of litigation is coming into the business specifically, because the tech industry is very far-reaching. There's different kinds of tech. There's fintech, there's tech within social media, there's tech within hardware, there's tech within so many different layers that you can't have a one-size-fits-all. And so the best way to do that is to have someone who really understands your business model, sees where the business is going. Everyone will be aware that by the time a technology issue comes up, such as, I don't know, chat GPT, it didn't just come up yesterday. People have been working on that product for years and years and years, and they've suddenly released it. Ultimately, you're not going to get to an outside counsel and be like, these are all the ideas we're thinking of, these are all the risks that can come. They're just going to be like, you shouldn't do this, you can't do this can't happen, blah, blah, blah. And so you need in-house counsel that both understand litigation risk, but also understand how regulation can develop, understand business risk, business appetite, and can combine all these things to give really practical business forward advice. And I think this is where a lot of law firms tend to kind of fail when it comes to advising technology companies. Very often the issues are, oh, well, you know, we gave them the best advice. Well, what is the best advice for a business? It's something that aligns with the business, that helps the business to grow, that makes the business money. And so you will see that there will be, as we go forward, more and more of companies deciding, well, actually, we're going to need our litigators in-house. So, I've just seen that there is a question. Felipe, should I take this now?
Absolutely. If you feel like that, you can either answer that now or later, depending on whatever you prefer.
Yeah, no, I'll go for this. Thanks, Katja. It says, how does my arbitration practice help in my role as an in-house litigator? I think that's a really good question. I think there's several elements to this. You can't just have arbitration, and obviously, well, you'll apply that, and this can come up in the sense of not just the arbitration cases themselves, but there will be contracts where you will be dealing with people. They seem like minor contracts, but they'll have arbitration clauses, and litigation will have to look at this. Or it can come up in the context of litigation. You might have an expert, you want to know, you want them to work with you, and the dispute resolution clause could be arbitration. Those are just some of the very practical, obvious ways. But I think one of the more interesting ways that my arbitration practice helped is that, I think I was saying this earlier, working as an in-house litigator is not just about being able to do litigation, understanding how litigation works. It's about finding the most practical way of working. And I think arbitration is one of those industries where people are trying to resolve disputes in a way that's often amicable. Very often people going into arbitration have to continue working together. That's the purpose. They've chosen arbitration because they want to keep their business secrets, but they also want to maintain a relationship. And so being able to work in an environment where I understand that there are other ways to have a dispute and get out on the other side has been very helpful in helping me to realize that I can come up with alternative means of, resolving things, but also alternative means of getting somewhere. It has been an eye-opener in terms of thinking of business practicality. I think that is the best way to summarize that. A few more questions I see. Do you still work with external counsel despite having specialized in-house practice? Yes, so this is a fantastic question, Veronica, thank you. We do. And I think it's a very good flag. I think as a litigator, it's almost impossible, even in-house, to not work with external counsel. Sometimes volume means that you have to, have external counsel, but also there's this element of having a symbiotic relationship, which means that the work or the prep that would go into litigation can be done efficiently. So to give you an example, when you're a litigator, in order to come up with the best case, you need to figure out the facts. You need to understand what your client wants to achieve. You need to understand how those facts fit into the narrative that you want to produce for your client. Now, in order to search for those facts, there's very often a back and forth. Oh, we need this information. Can you provide it? Oh, okay, now that we have this information, we need to analyze it. And I think when you have people in-house who understand the business, who understand how things work, who know where to look for that information, who understand how litigation works, who understand the purpose of a narrative, the purpose of getting things tight, the purpose of making sure that there aren't any loopholes in arguments, then you have very efficient colleagues on the inside doing that fact finding, creating that narrative along with you, which means that on the outside, you can think of practical things that relate to court benefits, cases that have already come up in the past, how a court might interpret it due to our expertise. You can say, I've been in this court many, many times. I know that in this jurisdiction, this is how things work. And then on the inside, you can be like, well, I know the business. I know that in the business, these systems would have worked like this for the past 5 years, but then they would have changed over the next 5 years. These are the reasons. And you create what I would call a larger symbiotic team. And I think in that way, you can't really separate litigation from an external counsel in its entirety. But this, I would say, applies mostly to big, complex cases. When it comes to smaller, nuanced cases, the benefits of having in-house litigation lawyers is that you don't actually have to work with external counsel that much. They become people who you consult if something is very tricky or very unknown, and it changes the dynamic of your relationship as an in-house litigator. Sorry, what are the things that I've seen external counsel do that are most helpful as an in-house litigator? I think in-house counsel that understand that I won't read a document that's 200 pages long are the most helpful. Because at the end of the day, I need, again, I know I'm now sounding like a broken record. I need practical advice that will help me advise the business, that will help me, make sure that what we're doing is both sensible, but also has the business purpose in mind. And if the advice from counsel is very verbose, it's very academic, it doesn't take into consideration business commercial sense, but not just general business commercial sense, specific to my business, then actually it's not very helpful. So I think concise advice from external counsel that really takes into consideration what I have said when I'm asking for the advice is the most useful. And also, it's not enough to give me options. You need to give options that tell me why you think option 1 is the best. Because at the end of the day, I can choose anything. I can choose anything from 10. I could have found all those 10 options myself. The purpose of having external counsel is to make sure that that external counsel is telling me that this option is the best for you as a business because, and alternatively, if not, this would work just as well because, right? So these are the kind of things that we would need to think about. I see Kevin has another question. What types of disputes does Meta have or you mostly work on? So I can't answer this in too much specificity, but I will give like a high level. any kinds of disputes you can imagine, honestly, we've probably got them. And that's only because when you think of a company at this scale and this size, it's very difficult. And I mean, you know, when I say any disputes, I'm not talking like criminal and, you know, that kind of non-civil dispute, right? I'm talking any kind of business dispute that you can think of will happen at a business at this scale. And that's simply because when you have a business at this scale, you have many, many layers of things that I think a small business wouldn't think about. At the end of the day, you rent a building, you need to be in the building. I'm sure like we understand that not every building arrangement will land in like a happy ending. You have billions of users. Not every user relationship will end in a good outcome. Excuse me. Regulation is developing at such a pace, and when you are one of the big companies in a space, you become almost the scapegoat for that industry, and that's not necessarily a bad thing if the regulation is doing what it sets out to do, right? But when that regulation or when that regulatory environment is not thinking about the environment, rather it's thinking about you as the company, that's when you start to have problems, right? You want the regulation to exist, but you want it to be thinking about the environment and not thinking about you as a specific actor. And I hope that's helpful.
Thanks a lot, Derin. I think we went through the questions. I think I have one as well, since you stopped your presentation. And thanks a lot for the answers. I think they were super interesting. You mentioned that you sometimes provide advice internally, and that's something that I find very interesting, because sometimes we think of dispute lawyers as being just, you know, advising on disputes. And sometimes in large organizations, there is a matter of defining a dispute. So when in the process is the litigation counsel involved? When should it be involved? So I was wondering whether you can tell us a little bit about that without being too specific, of course, but you know, any information regarding that would be very, very interesting.
That's a great question. And this can take many forms. So I guess, when should a dispute counsel be involved? Ideally from the beginning. From the beginning of any transaction, interaction, when you're considering the contents of the contract, when you're considering the engagement, if it's an engagement that requires you to give opinions that are supposed to represent the company, that is the point at which litigation should be involved. Not because you anticipate that there will be any litigation issues, but in order to prevent litigation issues. And that is a very valuable point. When you're an in-house litigator, your job is not just to handle the dispute when it arises. Your job is also to prevent the dispute. You're almost crisis manager, right? And so you want to be there from the beginning. However, that would not always be the case, right? And even if that is the case, there will come situations where you've done all you can do at the beginning, but then the dispute arises nonetheless. And I think in those situations, it's understanding how much of an issue something will be. Is this just something that requires clarification? If it's something that requires clarification, a disputes lawyer. If it becomes antagonistic, then it will definitely require a disputes lawyer. But I think another point at which you would have to consider, is this the right time for a disputes lawyer? Is this too difficult that I'm having to really think about it? I'm having to really search through the recesses of the business. I'm trying to really understand what is online. I'm spending a lot of time on legal databases. I'm spending a lot of time trying to really get to grips with what is being asked by this, claimant, individual, business. And if you're really having to ask yourself these questions, then that disputes should be involved, right?
Do you feel like internal procedures are clear-cut in this regard and helpful in defining when the dispute lawyer should be involved? In terms, for instance, in defining, the dispute resolution clause in a contract, or sort of skimming through the contract to see if there's any critical points, or just when the relationship is going to be difficult for some reason?
I think this question may be a bit specific, but I think I can come at this at a high level and say that in my experience with different companies, each company is a little bit different. Sometimes there are procedures in place and sometimes there aren't, but I wouldn't say that a lack of procedure means that a company is necessarily opening itself up to more risk. At the end of the day, if you are in full-blown litigation, your litigators will handle that work. But I think even at an early stage, if you're not involving litigators, for example, if you're in the UK, you would receive a pre-action notice before a claim gets to court, right? And so there is some scope or time for you to have your litigators come in before things get full-blown. But when I think about other jurisdictions where we don't have those steps and you can get straight to a claim, I think ultimately the point remains that you're not going to have a commercial lawyer think, oh, this looks like a dispute, but I'm very good at it and I can sort it out. Ultimately, all the people working on these kinds of things will be lawyers or law adjacent. And so we'll have some concept of when the right time is to loop in the right people, or if not, we'll have some understanding of the legal background to it. I think the worry should come if that issue is not sitting within your legal department at all. And so, yeah, I think to answer your question, yes, sometimes there are, no, sometimes there aren't. And actually, whether or not that will be a problem will be very case specific. I see that we have another question from Antoine. Can you share some expert tips about solving disputes that cannot be solved with users by customer relationship teams? I think this is a really interesting one, because I suppose as a litigator, my method of solving disputes would be often court or alternative dispute resolution based, as opposed to anything that relies on relationship management when it comes to users, right? The whole purpose of a customer relationship team would be to do that initial stage of the work. But I think a lot of the time, some of these issues do end up being solved through early negotiation, settlement sometimes, clarifying that there isn't actually a legal case. I think people forget that just because users feel that they have a dispute, it doesn't mean that there is a dispute that requires serious legal attention. And so I think another issue is understanding that you can explain to a user that something is not an issue without enraging them, right? So I guess a good example of that is, oh, you didn't like that someone posted this comment about you online. Unfortunately, this comment was posted by that person. It doesn't violate rules, and so unfortunately, there's nothing we can do. But maybe if this person is your friend, a helpful way would be to speak to that person and ask them to take it down. Do you see what I mean? Like, it doesn't sound helpful when we're just talking about it, but sometimes people are really annoyed and are not considering the simple options at the time that they're reaching out. I think everybody wants the big person to be the bad guy. It's a real David and Goliath situation most of the time. And I actually want to be able to point out that not everything is Goliath's fault, right? Some things can just be a misunderstanding or something that can easily be resolved without taking it that far. Great. So I did have, I think actually it was a good point for me to pause in that respect and just kind of answer these questions, because I think one of the things I did want to come on to was where I saw, the the role of an in-house litigator going in relation to the tech industry and what I can envisage will be the future, essentially. And I think due to the rapid nature of advances in technology, particularly now, we're seeing things coming up really, really fast. We're seeing that there's AI development, virtual reality, there's a lot of technological hardware that's being developed. People are very keen on the development, but there's also a lot of ruckus. There is worry. There's worry from regulators, there's worry from government, there's worry from individuals. And I think that what that means is that there's going to be a continued need for dispute resolution in-house lawyers, but it means that a lot of regulation is going to be coming into the space. It's going to be coming in rapidly, and there's going to be a lot of tension amongst jurisdictions, and it's really going to be for people for these lawyers to start to consider, what are these tensions? How can we resolve them? Thinking of those alternative means of resolution that I was talking about earlier, which is not just about, resolving issues once you've got them. Is about thinking, how can I get ahead of these issues? I can see that this country is moving in this direction. What can we begin to do to make sure that we're aligned with this country? How can they begin to see us as a player rather than as an adversary, right? And making sure that you are almost in a symbiotic relationship with the development of regulation where you can be, and making sure that as you're making developments, you're thinking, is this going to be a problem here? Is this going to be a problem there, particularly in big companies? And I think that the other thing that people are not thinking about is that there is going to be increasingly more scrutiny from the individual, the everyday person. And that is something that you don't get in a lot of industries. You don't find that traders are being scrutinized by individuals unless they have a background in trading and understand, right? It's a very niche specialty. And so it's understanding that everyone is watching and knowing how to deal with that. That's going to be really at the forefront of the work that is done in-house as a litigator in order to control the narrative, to control the issues that companies are facing. So, yeah.
That's super interesting. If anyone has a question, we still have 1 minute. In the meantime, I do have one. I think you touched upon a very interesting subject, which is dispute prevention, and it's at the forefront of what a dispute lawyer does, which is somewhat interesting because as a dispute lawyer, if you prevent a dispute, you're sort of without a job, but not necessarily. I was wondering on a related topic, when a dispute is already there, how much do you use mediation? How much do you believe in that? And whether in your experience is something helpful, whether it can be used, or if you can share any information, not necessarily specific to Meta, but in general.
Yeah, so I can tell you, rather than whether or not I use it in my work, I can tell you my perspective on it generally. And I think these things are very helpful. I think that they create a perception that you're willing to listen, which obviously you must be if you're going to go through mediation. But also when it comes to negotiation, the opportunity to hear the other side and see what the issues are also assists with your development later. And I think being able to be in a room, see what someone is seeing as an issue, being able to put your position forward gives them a better understanding of you, but gives you a better understanding of them, and informs your development going forward. So I think these things are extremely useful when used at the right time in the right way. They won't always be useful, but I think as companies, both big and small, manage the kind of dispute resolution relationships that they're in, they will begin to have a knack for when these are useful and when they're not, and they will then be in a better position in the long run. Yeah.
Great answer. I couldn't agree more. Well, thanks a lot. I mean, there are no other questions, but a lot of thank yous in the chat. I think everyone really enjoyed it. At least I did. So thank you very much, Derin, for your time, and I hope that we will have you again quite soon in our Web3 Tuesdays.
Thank you very much for having me, and I hope you enjoy your future sessions. Thanks, Felipe. Thanks, everyone.
Thank you. Thank you,
Bye.
everyone. Bye.
Thank you, Derin. Have a good day.
Thanks.
Thank you.